Have you ever wondered what a real-life whistleblower case might look like when taking action against your employer? Today we're going to go through what a potential case could look like. Here's a hypothetical for you. Daniel Brooks was a 39-year-old federal employee working as a procurement analyst for a major federal agency in Washington, D.C. His job? Reviewing contracts and making sure taxpayer dollars were spent legally and ethically. He'd worked for the federal government for over 10 years. Quiet, diligent, and by the book. But then Daniel discovered something he couldn't ignore. While reviewing a set of vendor invoices, Daniel noticed that a senior contracting officer had approved over $2 million in payments for services that were never actually delivered. The paperwork was sloppy, dates didn't match, and there was no verification record. After digging a little deeper, Daniel realized this wasn't an accident. It was a pattern. The vendor had close ties to a senior official in the agency. Daniel reported the issue internally, first to his direct supervisor, then to the agency's Office of Inspector General, or OIG. He documented everything: emails, spreadsheets, approval logs. The OIG opened a formal investigation. A few weeks later, Daniel's work life completely changed. He was reassigned to a meaningless role with no responsibilities. His performance reviews, previously glowing, suddenly turned negative. He was excluded from team meetings and stripped of access to key systems. Eventually, he was placed on a performance improvement plan, or PIP, for vague issues like, quote, team fit and communication tone. When Daniel pushed back and cited his whistleblower rights, things escalated. He was fired for insubordination just 2 months later. Daniel's case is a textbook example of unlawful whistleblower retaliation under the Whistleblower Protection Act, or the WPA. Here's why he has a strong case. He made a protected disclosure to OIG, reporting what he reasonably believed to be waste, fraud, and abuse. He has clear documentation of both the misconduct and the timing of his protected report. The adverse actions, reassignment, negative reviews, and termination, came directly after he blew the whistle. The agency's justifications for firing him are vague and inconsistent with his prior record, showing pretext for retaliation. Daniel can pursue his case through the Merit System Protection Board, or MSPB, and potentially even federal court if necessary. He may be entitled to reinstatement, back pay and benefits, compensatory damages, attorney's fees, and corrective action against the individuals who retaliated. If you're a federal employee who witnesses wrongdoing, you have the right to speak up, and the law is supposed to protect you. Retaliation for whistleblowing isn't just unfair, it's illegal. If something like this has happened to you, don't try to fight it alone. Talk to an employment attorney who knows how to protect whistleblowers and hold agencies accountable.